Good morning and welcome to Turning Your Ideas into Gold, the intellectual property webinar series with Bill Honaker. Good morning, Bill.
Good morning. Today we're going to be focusing on patents. Before we get started, I want to do a quick disclaimer. For our purposes today, this is just informational. There is no legal advice being given. If you have a specific legal question, I'll give you an opportunity at the end of the session in order to take advantage of a complimentary interview with me, and we can discuss your legal question in more detail. I want to start, just talk briefly about intellectual property in general. Intellectual property can be looked at as a spider web, and that spider web is made up of the four major categories of intellectual property: patents, which we'll be talking about in detail today, copyrights, trade secrets, and trademarks. Every business has copyrights, trade secrets, and trademarks. Some businesses have patents. These all work to protect your innovation, your business. But at the same time, this web can be a problem for you because it can entrap you in other people's intellectual property as well and get you some unexpected surprises. And I'll talk about some of those today as well. So briefly, quick overview. Number one, we'll be talking about the value of patents, how they're valuable. Number two, there are traps for the unwary, and these traps can completely ruin your ability to have valuable patent protection. I'll be talking about those. Number three, patent infringement can sneak up on you, and if it does, it is very expensive and very frustrating. And number four, in order to in order to protect all of your intellectual property and at the same time protect your business from surprises, I'll talk about a system that is very easy to use, a system that will protect your business from surprises and at the same time protect your patents. Mentioned value, I've talked about this before in previous presentations. Number one, value of intellectual property comes from higher selling price. If you have a product or a service that other people want and it's protected so that only you can supply it, you can demand a higher selling price. Number two, intellectual property can protect your market share. Same theory applies. Number three, additional revenue streams. Intellectual property can be sold and it can be licensed. I give the example of Hogan Manufacturing, company in Flint, Michigan. Very successful company in North America. They wanted to expand into Europe and into Asia, but they didn't want to pay the capital necessary to put boots on the ground. So what they did was they licensed a company in Europe with their intellectual property as well as one in Asia, and they collected royalties from those companies for their ability to use the intellectual property. Number four, protect your business reputation. This is really trademarks. You don't want to be confused with a competitor, particularly if that competitor is doing a bad job. And then lastly, greater business value. If you have a strong, well-managed intellectual property portfolio, it can be valued at 1/3 or more of the total asset value of your business. Many businesses today, those numbers are even higher, in the 80%. So let me give you a quick example of how patents play into intellectual property protection. This is a picture of a Bronco rollover. Back in the 70s and 80s, when SUVs were starting to become more popular, there were a lot of rollover accidents. And the passengers, the occupants of those vehicles, were suing the vehicle manufacturers, saying that the vehicles weren't manufactured properly, and the manufacturers were defending themselves, saying, no, the vehicles are fine, it's the drivers that are at fault. At that time, I met Tom Wallinga. Tom Wallinga was a engineer. He had a doctorate in engineering. And what Tom did was he would take the information from these rollover crashes and put that information into a computer simulation for trials. And he was doing this for a lot of trials across the United States, and he started seeing a reoccurring pattern, and that was this fishhook type pattern that occurred in every vehicle crash. And what he learned was, as the vehicle driver was heading down the road and swerved in order to miss whatever was in the road, the vehicle driver would then try to correct after missing the obstacle, and they would overcorrect, oversteer, and cause the vehicle to go into a rollover. And what Tom surmised being the problem was that the driver of the vehicle was forgetting to take their feet off the brake, or take the feet off the gas, or weren't applying the brakes properly. And he came up with an interesting solution for that, which I was able to get him very good patent protection on. And it was one of the first, if not the first, anti-rollover devices. And the way this worked was, if the device sensed the vehicle was leaning too far to one side, it would take over control of the engine, slow the engine down, take over control of the brakes, and start applying brakes properly. We were successful in getting a good patent on this. And shortly after getting the patent, Tom came to me and said, you know, I'd like to get a license, just a sample license. I'm talking to Ford and I just want to understand terms. So I drafted up a license. We talked about it. And then frankly, I didn't see Tom for quite a long time, lost touch with him. And about 4 years later, I was at an event and ran into Tom. And I asked him, I said, are you still doing the vehicle simulations? He says, oh, no, I retired from that. I said, retired? I think Tom was 35, between 35 and 40 at the time. And he goes, oh yeah, I've licensed every major automotive supplier on my patent. They're all paying me royalties. And Tom actually lives on an island off the coast of Florida and has been somewhat retired ever since. And I give this example to show the value of intellectual property. Without that patent, he had no way to convince anybody to pay him for his creation. He had solved the problem, very successful solution, and it's a solution that's still used today. And at the same time, he didn't have to manufacture anything, he just licensed his. That was the route that he took. All right, now, I've mentioned there's a lot of traps for the unwary in patents. I want to go through a quick quiz, challenge your understanding, and at the same time, give you some information about patents. Number one, if you have a patent on your product, you can still be sued for patent infringement. True or false? The answer is true. You can still be sued. The example I just gave with Tom Wallinga, Tom had a base patent on anti-rollover technology. Every technology that came afterwards, every improvement still was based upon his patent, and he was still entitled to get a royalty for that. And if somebody wanted to use anti-rollover, even though theirs was a vast improvement, and they didn't have a license from Tom, they were infringing his patent. Number two, a world patent protects you in every country of the world. True or false? That's false. There is no such thing as a world patent. If you want patent protection in another country, you have to get a patent issued in that country. There are ways to file for patent protection that are more efficient. I'm going to talk about those as we go along. Number three, you must file a U.S. patent application before making your invention available to the public. True or false? That is false. In the United States, you have a 1-year grace period. So you can disclose your invention, you can offer it for sale, you can make them, show them in public, describe them in printed publications, but you have to get the application on file before that 1 year expires. Otherwise, you are forever lost patent protection. You can't go back and solve that problem. And I see this happen all the time with businesses, with inventors. I get calls. Just last week, I got one of these calls. We have a great new solution. It's never been done before, and it's really doing well. Oh, it is? How long has it been doing well? 2 years. Sorry, I can't help you because you've been selling it for 2 years. You've missed this date. The other important thing to realize about this is other countries typically don't give you that 1-year grace period. They have what are called absolute novelty. So if you disclose in any way, you forfeited, jeopardized your right to get patent protection in any other country. Word to the wise is get an application on file before you disclose, and I'll talk about those filing strategies next. Number 4, in order to obtain patent protection, you have to be the first to invent the idea, true or false. This is false. You have to be the first to file. It's a race to the patent office. And if somebody else invents the same invention and gets there before you, you are out of luck. Again, a reason to get your applications on file as quickly as possible and before you disclose. Number 5, you have to put your patent number on your product, true or false. That is false. You don't have to, but it's advisable that you do, or you put a indication on your product where directing people to a website location where your patents are listed for those particular products. The reason is if somebody infringes and you have your patent number on your product, you can begin to collect damages from the date they infringe. If you fail to have your patent number on the product, you can only start getting damages after you put them on formal notice. Send them a letter with a copy of the patent attached. So it's always good to put your number on it. It's also good because anybody looking to copy your product is going to go and look for the patent and to make a decision whether they're going to have a lawsuit or not. So it's a self-policing function as well. All right, thanks for taking the quiz. You deserve a pat on the back. This is an actual patented invention. It's patent number 4608967, pat on the back apparatus. I show it partly because it's just an odd, funny patent, but also it shows an important point about patents. Patents do not have to be commercially viable. You can get a patent on a device similar, I'm sure, to this pat the back apparatus. I'm not sure that was a huge hit. You can get a patent on something even though it's not commercially viable. It has to work, but it doesn't have to be commercially useful. All right, I want to show you the types of patents that are available. The first is a utility patent. This is a patent on a salt spreader. Utility patents protect the function of an invention, and this patent protected a unique way of preventing salt from cavitating in the hopper so that it couldn't get to the auger. And it was a revolutionary patent in the salt spreader industry and really made the ability to make plastic salt spreaders possible as opposed to the previously metal ones. This is a design patent. This is the exact same salt spreader, but it's the design of that salt spreader that we are protecting here. And that design patents protect the aesthetic value of a manufacturing product. So it's the appearance of the product that they protect. And then lastly, very unique patent are plant patents. Plant patents protect asexually reproduced plants, and you can get patent protection for those, but they are extremely unique. In my career, I've never handled one, and very few patent lawyers do. All right, let's talk quickly. Just break in real quick. Any questions from anyone at this time? Okay. I want to talk about inventions in general and the steps you should take with regard to your inventions. Number one, do not disclose before you file. I talked about this. you jeopardize your foreign filing rights. You also start a clock in the United States, and if you miss it, you lose your rights to file. You should get a patentability opinion. They are completely, there's no requirement that you have to get them, but what they do is provide you with a good indication of the potential strength for your patent, what other technologies might be out there that are related, and gives you a good idea whether or not you should spend the money to go forward with full patent protection. If you're interested in protection in other countries, you have to file an application in those countries. There are ways of doing that that are more efficient, less costly. Lastly, with regard to new products, always get a clearance opinion on those. And that opinion could be as simple as, this is, your patent attorney indicating this is just a tweak to your existing products you've sold for 20 years. There's no problem there. But some tweaks can be patent protected and huge problems. So everything should be looked at. You don't want to get surprised by patent litigation. I'm dealing with a company right now that developed a product. They've been in development for 2 years. They launched that product, and immediately after launching got a notice in the mail with a patent accusing them of patent infringement. So they're in the middle of negotiations now, but here's 2 years of development, millions of dollars that may be lost because nobody thought to look before the product was launched. All right, I've mentioned filing strategies, so let's go through these. There are several. One strategy is you've got your invention created. You take advantage of this 1 year grace period in the United States to see if the patents or the product is going to sell and make patent protection something that you really want to invest in. At that point, you decide, all right, I'm going to file a provisional application because that will give me another year before I have to file my non-provisional. A provisional application is a simplified patent application. All the provisional cares about is a full and complete disclosure of the invention. You don't have to get into the very detailed drafting of patent claims, which are the scope of your invention. So in filing these provisionals, they can usually be done pretty quickly. The expense is less, and it gives you another year to see how well the product is going to sell. But because you went this route, you've lost your ability to file in most other countries. Another option here, instead of filing the provisional, you could have just filed the non-provisional at that 1 year point if sales were good and you wanted to proceed. But again, you've jeopardized or even lost your foreign filing rights. Another option is to file a provisional right in the beginning. That's a great idea. You can take advantage of your year. You get your non-provisional filed, and at that time, file foreigns as well. The problem with this scenario is at that period, you're paying for these foreign filings, and those are expensive. Every country has fees. Every country has their own lawyers that have to do the filing, so there's legal fees associated with them. Another alternative is you create your invention and you decide, I'm just going to file my non-provisional now. Within a year, you file your foreign because that's what all the treaties require. You file your US case or your provisional. Within 1 year, you need to file your foreign cases. That's fine, but again, you're front-loading all of your costs. They're all within 1 year. The best way to proceed, the way to push your costs off into the future and truly protect your technology, is to file a provisional as soon as you create your invention, file within that year a non-provisional, and then a PCT. PCT is Patent Cooperation Treaty. It's a treaty between almost every major country in the world. And what that treaty says is we're going to give you 18 more months before you have to file in any of our countries. So you've gotten 30 months to see how well this product's doing and really to make sure that foreign filings are necessary. Plus, you're getting your examination in the U.S. or a designated office. It could be in it could be in Europe, or it could be in Korea, giving you some idea of the likelihood of getting patent protection. That is the best route to take for a business. Any questions on filing routes?
No questions yet, Bill.
Let's talk about the parts of a patent. Every patent, now I'm talking about utility patents now, not provisional patents. Provisional patents, all it needs is a disclosure and some drawings. The importance there is fully and completely describe your invention. A utility patent, the non-provisional, the one that's going to get examined by the Patent and Trademark Office examiner. I'm a former examiner, and this is what I did when I worked there, examine these patents on a daily basis. They require a title, an abstract, a background, and these are all very specifically defined by patent office and court rules. You have to have drawings unless it's a chemical case that can't be drawn, but anything that can be depicted has to be in a patent drawing. And again, these are extremely detailed drawings, and there's pages of rules. We actually use independent patent draftsmen. That's all they do is make drawings for patents. You have to describe your drawings. And then you have to provide a detailed description of the invention. This is very detailed, and it has numbers. Every term you use has to be shown in the drawings, and the terms, the numbers have to relate to the drawings that are used in your description. And then lastly, the claims. The most important part of any patent application, any patent, are the claims, because that's your legal boundaries. It's like real estate. You're drafting a fence with words, and your words define what your invention is. Anybody outside of your word of defense, don't infringe. Anybody inside, infringe. And the negotiation with the Patent and Trademark Office examiner is they're representing the public in making sure you're not getting too broad a protection while you're trying to get as broad a protection as you can get within the rules. Mentioned the Patent and Trademark Office and the process. Your application is filed, it gets a filing date. 18 months after it's filed, it's made available to the public unless you agree you're not going to file for foreign patent protection. Examiner reviews and then searches for prior art. When I was an examiner, we literally looked at the actual printed patents, and they were called shoes because the metal boxes in which they were kept were like a shoe box, and they were stacked with patents, and you would literally go through them one at a time. Today, it's all done by, obviously, computer, quicker, probably more extensive examination than when I was an examiner. The examiner wants to first make sure claims are written correctly, that you're following all of the rules. Claims are written in a language that is different than the English language. It's defined by court rules. Claims can typically be very, very hard to understand because of those arcane rules as to description. The two questions he's going to ultimately ask is the invention new, and is it obvious? And the is it obvious is the one that mostly gets fought over. And the test is, would it be obvious to one of ordinary skill in the art to have come up with this invention based upon what everybody else has done throughout history? The examiner will issue an office action if he's refusing protection, and that happens 90% of the time at least, if not higher. And he'll explain his reasons for refusal. You get the right to argue. You get a non-final and then a final office action, 2 office actions for your filing fee. If you can't reach an agreement by that time, you have the right to appeal. And you can either appeal to the Patent and Trademark, well, you appeal to the Patent and Trademark Office first, and then you can appeal outside to a court. One thing I want to make sure you don't do is assume you can't get a patent. I hear this all the time, particularly from people who are involved in a field and have become experts in that field. They think, oh, everything I do is obvious because they're an expert. That's not the test. The test is one of ordinary skill, not an expert. Let me give you a quick example. This is a welding station. It's a typical welding station, been around for years and years. In the red area is where welding happens. That's where you'll have a robot or a person welding. That silver tube or a gray tube sucks the noxious fumes out of the red area, and it's pulled through that blue box on the backside, which is a filter, and it filters out those noxious fumes. Client came to me and said, I want to mount that on top of the welding station, and I want to get patent protection on it. I am sure that I can sell these, and there were 3 reasons. One, they got rid of that silver tube, and that had 2 benefits. It reduced cost, but secondly, it reduced maintenance because that tube had to be cleaned all the time because it was a fire hazard. Those noxious fumes cleaning the side of the tube get sucked into that filter, which is all paper bags or cloth bags. You would have a fire. So that was a real problem area. Lastly, putting that filter up on top of the unit saved valuable manufacturing space. We were able to get patent protection on this because we were able to convince the examiner that it wasn't obvious to one of ordinary skill. And the arguments we made were, just as I indicated, saving space, reducing costs, reducing maintenance, and the fact that if it was so obvious, why hadn't somebody done it before? And those were winning arguments. Now, you might be thinking, this looks pretty obvious. And 10 other companies did. During the life of this patent, we had to assert it against 10 companies. Everyone said, that's obvious, you should have never have gotten a patent. Nice thing about patents are they're presumed valid, and to prove they aren't valid costs hundreds of thousands, if not millions of dollars. So every patent, no matter how weak you think it is, can be very costly to prove that it should not have been ever issued and that you're not infringing. All of these companies backed out once litigation started because they didn't want to spend that kind of money. And this product literally made millions of dollars a year because it was the only product that could be put into manufacturing facilities for the purpose of saving floor space.
We have a question from Chuck Turin. He's asking, is defining the invention are you best to define definite points or be more broad?
Both. In the definition, you want to completely describe the invention. So you want to put as much detail as you can that are relevant to the invention. And then in the claims, so that's very detailed. In the claims, you want to only put in as much detail as is required to get the patent allowed by the Patent and Trademark Office. So that's being broader. And then you can, as part of your claims, add in detail in what are called dependent claims to make it more definite in case someone comes in and argues your claims are too broad, you shouldn't have been granted a patent. You can then rely on more specifics in your dependent claims. Did I answer the question, Chuck?
Yeah, it's good. I just know that as we did it in our products, as you remember, it was to try to get it. It was a balancing act, wasn't it? To not be broad and be sure we had specifics that people couldn't get around. I just wanted to know, how do you balance that?
Yeah, it's partly based upon that patentability search. Then you get an idea of what others have done and what what's close to your invention and what you have to get around. It's also based upon what you as a business owner believe to be the heart of the invention and what we really have to get protection on. And then that balancing act is putting in enough claims to build that fence so that you can capture infringers and they're not getting around your patent. And I'll give an example later about the importance of the words in claims. But you're absolutely correct. It is a balancing act. And frankly, that's where good patent counsel is, it determines the strength of your patent and determines the type of protection you can get, because good patent counsel spend a lot of time drafting those claims, understanding what's important to the business, and making sure that you're getting the protection that you need. Another important point with regard to patents is you have to correctly name the inventors. It is critical. And here's an example of why this is important. In patent law in the United States, every inventor has an equal undivided interest in the patent, meaning they can do with it as they please. If you have two inventors, each can go out and license anybody they want. And the only way to prevent that is to have those rights assigned to a specific entity, whether it's one of the inventors or to a company. But if you leave those inventors alone, it will completely devalue your patent. You have to get them assigning to a specific entity. And this is an example of it. This was a trocar developed by Ethicon. Trocars are surgical instruments. The device on the bottom is basically a tube. They make an incision and they insert it in a person's body. And then the device on top is the actual surgical instrument that gets inserted into the tube. And on this case, the end of it was a cutting device and a stapling device. So they could fire the trigger and cut and staple at the same time. So there's less blood loss. And it was used for removing tumors, et cetera, in a human body. Ethicon got patent protection. They sued their arch rival, US Surgical. Huge battle ensued in court, and US Surgical during discovery learned that there may be another inventor. So they went out and talked to an individual by the name of Chu, and they said to Mr. Chu, we think you should have been named as an inventor. If we can convince the court to name you as an inventor, we'll pay you $100,000 if you assign your rights to us, because we can have this case dismissed because you're assigning your rights. You have equal rights to anybody else that was an inventor. And because they failed to name you, we can get out of this lawsuit. And that's exactly what happened. The court determined that Chu should have been named as an inventor. As soon as the court determined that, US Surgical said, here's my assignment. We own an equal undivided interest, and they dismissed the lawsuit. That's the reason you want to make sure everybody that is named as an inventor is properly named so that you don't lose your IP rights. It happens. It's not something that happens a lot, but right now there's another case, Dana-Farber Cancer Institute versus Ono Pharmaceutical, that's going to the Supreme Court just on this issue. And Dana-Farber lost its patent because they didn't name two US inventors. And they're telling the Supreme Court, this is too confusing. We need a better definition. And they're hoping the Supreme Court will save this very valuable cancer fighting drug that they've lost because they didn't name all the inventors they should have. All right, I mentioned in the beginning a process to protect your intellectual property and at the same time protect your business from surprises. It's the three-step process: recognize, collect, and protect. I refer to it as the recipe for success. And The first step is recognize. It's what we're doing over these four talks. And that's where you recognize you have trademarks, copyrights, maybe patents, depending on your company, and trade secrets. Every business has three of these four. Every business has trademarks, copyrights, and trade secrets. Some will have patents, and that's obviously what we're talking about today. Collect is the stage where you collect everything that you've recognized as being potential patent or potential intellectual property. It's also where you collect new product launches that need to be looked at. In collecting your intellectual property, there's a shortcut and an easy 2-question test. You can train your employees to do this. The test is it important to your business? If the answer to that is yes. The second question is, would you rather your competitors not have it? If the answer to that is yes, then it is likely to be something that can be protected, and you should then discuss it at the last step, the protect step. Double click there, sorry. And the protect step is when you get together with your counsel. This should be done quarterly at a minimum. If you have a huge patent portfolio, you may want to do it monthly. And what you do at this meeting is talk about everything that you have collected and then discuss protection options. Protection options come at a cost. They're a lot less expensive than you may think, but you don't want to protect everything. You want to protect what's important. And this is where you discuss this with your counsel. And then lastly, review new product or service launches. You want to do that. You don't want to get surprised by litigation. Again, it's a web, and that web includes your competitors' intellectual property. And in patents, you can innocently infringe a patent. You don't have to even know it exists, and it can surprise you when you launch a product or when you're selling a product and you find yourself in an expensive litigation over a number of years. To make these easier, you need to have a system in place. The system that I've used for years is a status sheet, and that status sheet puts all the important information regarding the company's intellectual property in very readable, very easy to understand blocks of information. In this case, this happens to be one that we did for Trinex. All of this information is publicly available, so I'm not disclosing any of their information. But what this shows, the first one is the reason I took this page. The first one shows a utility patent, the second one, the design patent, and then a couple of trademarks. And what this task or status sheet does is it continues every quarter, remind the business of the intellectual property portfolio, what they have, gaps they may need to fill, what they're paying for, because intellectual property, some of it has maintenance fees. And if you're not watching it, they can be paid even though that technology may now be obsolete or of no value anymore. So this keeps your intellectual property front and center. Now, I mentioned earlier, if you have legal questions, general questions, I'm more than happy to answer today. But if you have a specific legal question and need legal advice, I offer a complimentary half-hour consultation. You can call. We'll set up a call to discuss any IP issues you have, identify any gaps you may have in your intellectual property. If you want, I will help you collect your intellectual property. Most companies assume they know what they have in the way of intellectual property. I speak across the United States on this topic, and it's pretty common for me. When I get ready for these presentations, I search some of the company's intellectual property, and it's pretty common for me to find intellectual property that has expired. They've lost trademarks or patents that are a complete surprise to the business owner. It's also common for me to show business owners their intellectual property portfolio and they realize they've been paying a lot of money to maintain patents that are no longer relevant. That's one of the main purposes of collecting your IP, to actually understand what you have. If you want to set up a meeting, email me at bill@ipguy.com. I'll set up a time, or you can call me directly at 248-433-7381, and I'll set up a time to discuss your intellectual property in greater detail. Any questions right now before I move on?
Nope.
I mentioned the importance of claims. And the Hogan Drill is a perfect example of why claims are important and the need for skilled intellectual property counsel in drafting your claims. Doug Hogan was an inventor. He had over 400 patents. He also was an entrepreneur. He had a bunch of different businesses. One of his businesses was Hogan Manufacturing, that manufactured mag-based drills. This was an early embodiment of one. Here's a more recent one. And mag-based drills are basically portable drill presses. They have a drill motor mounted to a magnet, electromagnet. So when the magnet's energized, it can be mounted to metal. And they're used a lot in high-rise building construction, bridge construction, et cetera. The problem with mag-based drills is if the drill bit gets stuck, the mag base has a tendency to wildly spin out of control and was known to hit workers. One of those workers happened to be Doug's brother. He got hit by one of these mag-based drills and was thrown off a building and unfortunately plummeted to his death. As a result, Doug decided, I have to fix this problem. And he came up with an ingenious solution. What he found was if he could just create a little bit of drag, he could prevent that mag base from spinning out of control. And what he did was he added a metal punch at the back of the mag base. And all he had to do was slightly penetrate the work surface to create that drag. The device he used to get the punch penetrated was a slide hammer. And what a slide hammer is, it's a tube that's closed, and you raise it up and strike it downwardly onto the steel punch to get it to slightly penetrate a metal surface. Doug put these on the market, was selling them. They were very, very successful. And Doug's arch rival, Black & Decker, decided they had to have this kind of a safety device. And they came up with a device that was like a motorcycle helmet handle. You would twist it in order to force that punch into a work surface. Doug sued. There were millions of dollars in damages at stake, millions of dollars in future sales at stake. And the one issue the jury had to deal with was two words in the claim. And those two words were strike downwardly. Doug's lawyers at the time, I was not the lawyer, it wasn't my law firm, I had nothing to do with it. They wrote claims to the commercial embodiment, and that was a slide hammer that you would strike downwardly. They weren't thinking about the heart of the invention. Nobody cared how that punch got into the surface. The heart of the invention was getting that punch to penetrate the surface. Doug did it with a slide hammer. Black & Decker did it with a cam. They cammed that punch into the work surface. And the question of the court was, is this the same as striking downwardly? And the court found that it wasn't. And Doug lost that case, lost millions in damages, millions in sales, because his lawyers didn't use broad language like force down, drive down. Nobody cared that it was struck down. Thank you for attending. If you have any further questions, I'm happy to stay after and answer them. Thanks again for being here.